May I please, Your Lordship? I beg to mention item number 6, my lord. My senior is suffering from severe back pain, my lord. Kindly adjourn the matter today and fix the matter next week.
Who is your senior?
Mr. R. Dubey, Rakesh Dubey.
Rajesh Dubey.
R. Dubey.
R. Dubey, yes.
Dubey, yes, telephonically. He called me also, madam. Severe back pain, he is in bed.
R. Dubey is for?
Respondent number
respondent one.
But his name is not there in the cause list.
He is appearing for respondent number 1 and Borpujari for respondent number 2. Three.
Mr. Your good name?
A.N.I. Hussain.
Learned counsel appearing on behalf of Mr. R. Dubey.
R. Dubey, yes.
Learned counsel for the respondent number 1 with consent from the other side. Press for listing the matter on when?
On 18 June, Tuesday. 18 June.
Okay.
May I plead your lordship? I beg to mention item number 5, IA criminal 65-23. May be allowed to withdraw.
IA.
Yes.
And this is a main appeal?
IA criminal 653-23.
No, this appeal, this IA is tagged with criminal appeal. You want to withdraw both the matter?
Both the matter, no. IA criminal only.
Only.
All.
Acha. Your good name?
M. Soikia.
Ms. M. Soikia, learned counsel appearing on behalf of Mr. M.U. Mahmood, learned counsel for the applicant.
653-23.
Submits that she has the instruction to withdraw this IA, being IA, which indicates CRL 653 of 2023. Why do you want to withdraw this matter?
My senior is not prepared in this matter, so
Here is accordingly allowed. This IA criminal so and so stands a disposal of withdraw. Yes.
all right, lordship.
May I please, your lordship? Lordship, I beg to mention item number 7. Lordship, due to some personal difficulty, my senior is not available here today, so kindly adjourn the matter for today, lordship.
Who is your senior?
P. Mahanda,
Your name?
M. Borgohain.
Ms. M. Parmoy, learned counsel appearing on behalf of Mr. P. Mohanto, learned amicus curiae. Press for listing the matter when?
Any date?
On 20 June.
20. Okay.
Much.
Item for admission, item number 1.
Please, Your Lordship.
Lordship, as per the prayer made by me, I filed an additional affidavit, Lordship.
Yeah.
Yes, here.
When?
Today morning, Lordship, I have a copy to my brother.
Yes, my lord, I received.
If it is tagged with the record, I can proceed. If it is not tagged with the record, I shall pray. It may kindly be tagged with the record. Yes, today morning I have filed. I don't think it has been tagged with the record.
No, you could have informed the court master earlier.
Yes.
Then we could have called it.
I beg your apology, Lordship. I beg your apology.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner, and Mr. Ziuddin, learned counsel for the respondent number 2. And Mr. B. Sharma, learned counsel, learned additional people for the respondent number 1. Mr. Bhattacharya submits that he has filed one additional affidavit.
Today morning at around
Today morning,
11:30.
but the same is not placed on record. And accordingly, it is provided that rest is the matter on along with the additional affidavit.
13th, no, 10th, Lordship. 10th.
10.
10th. Interim may continue, Lordship.
Till next day, interim order, first earlier shall continue.
Deployment.
Bail hearing, item 2.
May I please, Your Lordship, after some time,
after some time.
Item 3,
May it please your lordship. This is a 439 application, your lordship. The petitioner was arrested on 16/7/2022, your lordship. And it's a matter of NDPS matter on the section 22C. Your lordship, cough syrup, codicil was recovered. Here, your lordship will find the FIR at page 60. 16 is the FIR, and the main FIR is at page 11.
This is second bail application.
So that is the, and your lordship can take the typed copy. Oh, sorry, the FIR, main FIR is typed FIR is at page 8.
No, Mr. Mannan, this is second bail application.
Lordship,
This is second bail application.
this is a second. That is why your lordship, it has come before your lordship. Your earlier rejection order, your lordship will find.
So
That is-
what is the ground?
The ground now, your lordship, what has happened? Now, there were 11 witnesses, your lordship, in the whole matter from the charge sheet. Out of the 11 witnesses, a few days back, the last 9th witnesses has taken place. Now, the petitioner was behind bar for about 1 year, 11 months. So, we have filed an affidavit also, additional affidavit, bringing on record the a few witnesses, PW 8, 7, 8 and 9. So 9 witnesses have already taken place. Now, your lordship, from the witnesses on record, if your lordship will kindly go through that, I'll take your lordship to that. And basically, there are Caesar and witnesses and as well as independent witnesses. None of those witnesses have specifically made any allegations against the petition. Now, what has happened, your lordship? The main accused was caught. The main accused, the co-accused has named the petitioner, and on the basis of the naming of the co-accused, I was arrested. Your lordship. After my arrest, the police had said that some cough syrup has been recovered from me. But from the search and seizure witnesses, your lordship will see
Okay, so altogether 9 witnesses have already been
Already
examined.
that was last witnesses examined. The 9th witnesses was examined on very recently, your lordship. I have filed it
Yes, Mr. Sharma,
on
two witnesses
22nd
are,
May.
yet to be examined. Have you gone through the one?
Yes, my lord, I have gone through, my lord. There are 7 witnesses statement are there, my lord, in the record, my lord. 2 perhaps not.
Actually, these 2 we have not annexed because this is with regard to the other accused person. There's
In
nothing to do with
in the
the
record
present
also,
accused.
it is not available, my lord. Only 7 witnesses statement is available, my lord. And my lord, IO not examined, my lord.
No, whether a statement of those 2 witnesses available with you?
The other 2, your lordship,
Yes,
which has not been annexed.
yes.
That is with me because why I have not annexed, the ground is that the original accused person, main accused person, they are with regard to search and seizure from the main accused person, nothing to do with this present petition. 2 persons were arrested in
Maybe,
different
but
places.
if that is not available on the record, then either we have to call it from the court below, or you can file it by way of additional affidavit.
If your lordship wants, I can file. I have this copy of both the. No, scan copy to scan copy, I think.
ISIS cannot have that.
ওই দুটা, I have a copy of these certified.
So you
If your
file it,
lordship
then
want, I can.
we take it up on Thursday, okay? You file the additional affidavit by tomorrow?
Right.
Heard Mr. Y. Mannan, learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. It is submitted at the bar. The LCR has already been received from the learned court below. And out of 9 witnesses examined by the learned court below, only the evidence of 7 witnesses are available. But Mr. Mannan, learned counsel for the accused, submits that the statement of the said 2 accused are available with him, and he will file an additional affidavit enclosing the statement of those 2 witnesses. And price for granting in 2 days' time, there is accordingly allowed. Rest is the matter on Thursday.
If somehow your lordship, if it is not, we can call.
Yes, we can call, you can inform the court master earlier.
Much.
item 4, Many which are lost, 439 bail application lawsuit. So in this case, lawsuit, earlier lawsuit rejected this petition lawsuit.
No, on the
Because
other day,
after
we have
the-
adjourned the matter on the pair being made by you.
Lawsuit,
What is the ground for adjournment?
last date was, lawsuit the 29/5 was the last date, we put a trial court.
Hmm.
On that day also, one witness has been examined lawsuit.
You got the evidence.
I applied for certificate, but not yet received lawsuit.
So Friday then,
Also certificate copy, I have applied. But
oh,
also can call for a scan copy also.
scan copy.
Up to date scan.
Up to date scan copy.
Scan copy is already there, madam.
Up to,
Pardon,
out
sir.
of 11, 6 already examined. I have annexed, file an additional affidavit by the, 6th lawsuit, which I have received lawsuit. But another also examined.
Learned counsel for the accused and Mr. B. Sharma, learned additional BP for the state respondent. Mr. Gogoi, learned counsel for the accused submits that as per his instruction, one more witness has been examined by the learned trial court. And as such, the evidence of the said witness may be called for from the court of learned, from the learned trial court. Here is accordingly allowed. Registrar shall call for the up-to-date status report along with the evidence of the witness examined on
On 29/5.
29/5. List the matter on Monday then,
Lawsuit,
12.
On 12 June. Lawsuit the next day before the trial court 26. Now date of death.
12 then,
Lawsuit. 12 June.
Earlier.
Item 8 for hearing.
May it please your lordship. My lord, in this case,
so on the other day, the question was, this,
yes, my lord.
sudden fight.
Yes, my lord. My lord, I have found the provision only, my lord, exception of my lord, 300.
Section 300,
Yes, my lord.
exception number 1,
Yes,
1 or 2.
One,
Then
my
sudden provocation
yes, my lord.
or sudden fight.
Sudden fight, my lord. So, yes. And my lord, it's also found explanation 4 and 5 also, my lord. And explanation 3rd also, my lord, whether provocation was grave or and sudden enough to prevent the offense from amounting to murder is a question of fact. And my lord, the explanation, exception 4.
Hmm.
Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion upon sudden quarrel, and without the offender having taken under advantage or acted in a cruel or unusual manner. So, my lord, it is in case of my lord 302 generally, but 307 also, my lord, I have found some judgment, my lord.
307.
In
Okay.
My lord, I have taken another point also, my lord, because my lord witnesses, my lord. 2 of the witnesses are interested witnesses. One is son and one is daughter, my lord. And another witness, my lord, is a neighbor. He stated
No,
he has the
Mr.
Yes, sir.
Uddin,
person.
the accused is the father of that witness.
Yes, ma'am. That's why, my lord.
Hmm. So he is related to both sides,
Both
the
sides.
victim and also the accused.
And my lord, I have found some judgment, my lord.
Hmm.
Though it was, my lord, 307, the court, my lord, sometimes punished, my lord, 2 years, sometimes 3 years, my lord, sometimes 5 years on the point of my sentence, my lord. And this,
So how long you were behind the bar?
my lord, almost, my lord, 6 months, 11 days. my lord, from the judgment. And before that, my lord, from the record I have to check.
8 months, 6 days.
8 months, 6 days. From the, my lord, judgment. So if it is, my lord,
What will
320.
happen if we reduce the punishment? You will again start the same problem to them.
My lord,
Hmm?
may not be, my lord, he is become age of, my lord, now 53 years.
Hmm.
So that point, my lord, lordship may consider, my lord.
Hmm.
The already
Yes.
given, my lord, 8 months, 6.
Ali?
Lordship, if I go the statement, evidence of PW 3 and 5 for the son and daughter, the eyewitness of the incident. From their statement, my lord, clearly, my lord, intention is there. The exception of 300, exception 1 may not come, my lord. Because
301, that is not applicable here.
Lordship,
But the principle is discussed there
Yes, ma'am.
because this is not a case of murder.
Lordship.
And my lord, from the medical examination, my lord, there is no clear description, my lord. And the medical officer, my lord, who was initially there, he was also not examined. And lordship may kindly see the medical record, my lord. Though there is a, my lord, the description, but it is how much depth, my lord. And that cutter was also, my lord, seized after 4 days. And not in presence of the, my lord, present accused, my lord. And not sent also for a signal. So some lapse is there, my lord, from the part of the prosecution. Only, my lord, 4 centimeter and then 3 centimeter like this one.
Name of the victim is Malaka Khatun.
Yes, madam.
The injury, nature of injury is simple.
Simple, man. And doctor also said that, my lord, it may be from fallen also. When in, my lord, cross examination. He cannot ascertain whether it is what kind of weapons.
Where is the examination of the doctor?
Doctor, PW 7.
PW 6.
PW 6, man. Dr. Suleiman. Yes, ma'am. Kind of description of the injury. Alleged history of physical assault at around 7 p.m. on 30/10/2020. There was loss of consciousness. There was no ENT bleeding and vomiting. On local examination, there was pre-stitch wound on frontal region 4 centimeter and on occipital region 3 centimeter. There was another pre-Swiss wound on right scapular region of size 8 centimeter. There was swelling and tenderness on right forearm. As per report, the nature of injury was simple. Type of weapons could not be determined as the injury was stitch. Remarks. X-ray reports were not attested. While writing in this report, the hospital number so and so, medical legal number so and so. there was an issue registered, and the issue number is so and so. My lord, exhibit 5-6 medical legal report, my cross part, my lord. I have prepared the medical report by seeing the medical register. There was not mentioned who escorted the injured patient and the address of the 307, my lord. The court, my lord, held it, my lord, in the, my lord, part of sentence, my lord. So leniency is there, my lord. But in this case, my lord, when no leniency as such is given, my lord. Even if, my lord, it is fall in 307, my lord. So maximum is, my lord, 10 years, my lord. Maximum limit is given, my lord, but no
So
lower
here only
limit.
5 years,
I will give 5 years, my lord.
then
In some court, my lord, it is given 2 years, 1 year also. Another, whatever, my lord, already gone. Yeah, my lord. This discussion is lost.
keep it as partnered. Before we sort that,
On 13 June,
sort that.
11.
17.
Heard Mr. Ziuddin, learned counsel for the appellant, Mr. R. Ali, learned counsel for the respondent number 2, then Mr. B. Sharma, learned additional LPT for the respondent number 1. Argument of Mr. Ziuddin, learned counsel for the appellant completed. Please the matter on 11
11.
as partnered.
Pending item 2.
Oblige, your lordship.
Yes, Mr. Ahmed, on the other day you have referred one judgment.
Lordship.
This one perhaps,
Uh,
uh,
Hasanuজ্জামান and another
Mujibur Rahman,
versus State of West Bengal. Hasanuজ্জামান versus State of West Bengal.
acha. Yes, Mr. Kyle, have you
No.
gone through this
Yes,
judgment?
Lordship, I have gone through that order. This is not a judgment, this is an order, Lordship,
Hmm.
passed by the Honorable Supreme Court.
Hmm.
Lordship, may yet to please to see. Here in this case, the bail was granted on the ground that there was no criminal incident of the petitioner, as well as there is a delay in trial. But this cannot be become a precedent. First, Lordship, please to come to page 82. The role of the present petitioner. The part of my objection filed by me, Lordship.
Hmm. 82.
Page 82, paragraph 43.
But till now, no witnesses have been examined. Even
Charge
charge
has-
has also not been checked.
Charge has not been framed. Lordship, two accused, there are 3 accused persons
Hmm.
who have been found absconder. Process has been issued, available warrant has been issued, non-available warrant has been issued against them. I have checked up the record, Lordship.
No, why don't the trial court has split up the matter?
No application has been filed either by the
No,
petitioner,
is it necessary to file an application?
probably,
Not necessary. Court can so moto.
yes, court can.
Or he
also-
can file a verbal
Yeah,
payer also.
I
No,
have
he
checked,
can-
Lordship, she do not have any legal assistance there. I have checked, I have brought on record also that fact.
Legal assistance
Yes,
means
she has no engaged counsel there.
there.
Yes. And
Whether
court has
legal
also not
counsel
appointed
is
any legal-
provided to her.
No, legal aid counsel was also not appointed.
Yes, page number?
Page 82.
Yes.
Paragraph 43, there the seized 289.210 gram of heroin was recovered from the conscious position of the arrested accused Anita Pal.
Hmm.
Then state bill also may come to paragraph 47.
Hmm.
I'm speaking two paragraphs. For paragraph 47, that during the house search of Anita Pal, financial documents and bail order passed by the Honorable Court District Senapati Manipur, having criminal case number so and so, FIR so and so, State of Manipur versus Anita Pal was found.
Acha, that is our criminal antecedent.
Yes, Lord. And she was found involved in trafficking of 29,270 numbers of equivalent drugs in 2018.
So, the sum and substance of this judgment referred by him is that trial is delayed, and as such, the condition of 37 to stands
But Lordship,
satisfied.
in my humble submission, this it cannot be a precedent. Because nothing, Honorable Supreme Court has also observed that nothing has been observed in merit of the case. And Lordship, one line is there that there was no criminal incident of this present petitioner. Lordship.
Acha.
That is
But
al-
this petitioner has a
Yes, he
criminal
has
license.
also criminal and heroin has been recovered from him. And Lordship, in this case, 110 bottles of fentanyl was recovered from the three persons. Lordship.
Hmm.
So Lordship has to see the gravity of the offense also. And delay in trial in such cases cannot, and Lordship, that she was arrested on.
No, even then, 115 bottles of phencyl cough syrup is a commercial quantity.
No, yes, Lordship, but Lordship, here Lordship, heroin has been seized. That is also more than commercial quantity, 300, 289.
Both are commercial quantity.
No, Lordship, even then, Lordship, the gravity of the offense is also be seen by the Lordship. And furthermore,
Since,
Lordship,
both are commercial quantity,
no, that is correct, Lordship.
then
Even then, Lordship, there is this order cannot be a precedent. Because this is not a judgment. Lordship knows that what will be the ratio resident and which will be the binding precedent. Because nothing has been on merit, nothing has been discussed in this case. Lordship. Simply, the Honorable Supreme Court observed that there was a trial and there was a direction of the Honorable High Court to complete the trial within 1 year from framing of charge. Here, Lordship, Learned Trial Court has issued the process against the absconder accused. And there is a criminal, and Lordship, one line is there in that there is no criminal incident of this to the three petitioners. But whereas it is this present petitioner has a criminal incident, she was also arrested in case of commercial quantity. Although she was granted bail by the learned court in Manipur. So tactics will definitely come into play. And Lordship, as observed by your Lordship in another case. Lordship has referred 3 judgments placed by me. With regard to delay in trial, that cannot be a ground in case of commercial quantity. And regarding delay in trial, that has been also referred into. Regarding splitting of the trial and regarding legal assistance, please, she is entitled to legal assistance.
no, if she want legal assistance, she can make a prayer before the trial court.
And Lordship, another thing, she can take assistance of counsel here in the High Court regarding seeking bail. But why, what happened to the trial, Lordship? That is also a big question, Lordship.
That is a difference, sir, because I was engaged by her relative only for the bail purpose. Whether she has that
You
right.
cannot go there unless you.
Yes, unless.
No, Lordship, I'm
that
not speaking about my learned friend, Lordship. I'm speaking the intention of the petitioner or her relative.
No, if trial has not commenced, that if she can file any application, that has to be communicated to her. That before starting the trial, she can engage a counsel.
Definitely, why not?
Whether that was informed to her or not, that I do not know, Lordship. And without knowing anything, we cannot comment on that.
No, Lordship, I'm not accusing my land, I'm not making any comment my learned
Because
friend.
trial has not yet
I'm
started.
just making the intention of the petitioner or her relative. If they can engage a counsel in High Court seeking bail, what prevented them to engage counsel for in the trial court?
In the trial court.
Yes, Lordship. This is a reasonable question.
Any other point, Mr.
That already I have submitted, and one more judgment, Lordship, just.
Yes.
Just I will give the copy, Lordship, it is there, just I have misplaced it. I will place that. 2017 5 SCC 702, Lordship. Here also said that, just one line I'm reading,
2000.
17.5 SCC,
Hmm,
702.
yes.
Here
So what
regarding
is the
that,
ratio there?
Lordship, that Article 21 and speedy trial. Here also there's one line I'm reading, Lordship. Direction was given in paragraph 29. Paragraph 29.1.2. Magisterial trial where accused are in custody be normally concluded within 6 months, and sessions trial where accused are in custody be normally concluded within 2 years. So that direction was there. And just another aspect why I'm relying on this, Lordship, that even NDPS Act, section 36, if your Lordship takes up, that also says about speedy trial. Section 36. So that the government may, for the purpose of providing speedy trial for the offences under this act by notification in the official, so that for speedy trial, this special courts were constituted. Section 36, Lordship, may see. The purpose of this construction of this establishment of this special courts was for speedy trial.
So we reserve the order then.
Lordship.
But may I submit one thing?
Yeah.
See, with regard to 36A, but see, it is not that the trial is not proceeding. Or not,
Pardon?
the trial is not stayed or not proceeding. That is not the case. Lordship, I have seen the order every day, in every month, Lordship, trial date is fixed by the Learned Trial Court. The process has been issued. And trial is proceeding, Lordship. Yes, for a default of the 2 accused persons.
No, trial will start when? After framing of
Okay, after
charges.
framing.
No, no, once the complaint is filed, Lordship, I'll produce that judgment. That judgment is there.
Pardon?
Once complaint is filed,
Hmm.
it means the trial has been begun.
No.
Yes, Lordship, that is judgment of Honorable Supreme Court. I placed before another court.
Hmm.
And Lordship, it is not case that the court has not passed. Court has taken cognizance. Court has issued process against the accused who has not who was found absconder, Lordship.
Hmm. No, since she is a lady and languishing in jail for more than 2 years, the court could have split up the matter.
Yes,
and
Lordship,
proceeded against
that could have been, Lordship. That could have been, Lordship.
So what prevents the trial court from splitting up the matter?
There is no bar before the trial court for pleading the case.
Ah. Okay, heard Mr. A. Ahmed. A. Ahmed, Learned Counsel for the accused, and Mr. S. C. Khair, Learned Standing Counsel for the NCP. Argument concluded, order is up.
Much of it.